If you own a gun in America, stop what you're doing and listen. Everything you thought you knew about your rights just changed, and almost no one is talking about it. This November, a federal appeals court dropped a ruling so massive that it's rewriting firearm laws across the entire country. 10 new legal changes are now in motion, each one powerful enough to reshape how every gun owner lives, carries, and defends themselves. Some of these laws will expand your freedoms like never before. Others will expose traps that could cost you everything if you're not paying attention. So make sure you hit that subscribe button and ring the bell right now. Because the difference between knowing what changed and missing it could mean the difference between freedom and a courtroom. Let's break down the 10 changes every gun owner needs to understand immediately. The first one isn't just big. It's the foundation that makes everything else possible. Number 1, strict scrutiny is now mandatory. For decades, courts allowed lawmakers to pass gun restrictions without real proof that they were necessary. Judges often gave the government the benefit of the doubt, letting emotion override evidence. Those days are over. The November ruling confirmed that every single firearm regulation in America must now pass the strictest legal test available, something called strict scrutiny. From this point forward, anytime the government wants to restrict your gun rights, they must prove 3 things beyond question. First, that they have a truly compelling reason, not just a good idea. Second, that the law directly achieves that goal. And third, that it does so in the least restrictive way possible. This change flips the entire burden of proof. The government now carries the full weight of justification, not you. Thousands of existing laws could crumble under this new standard, and that brings us to a protection that could literally save your life and your savings. Number 2, civil immunity for lawful self-defense. For years, Americans who defended themselves successfully with a firearm still ended up destroyed in civil court. Imagine this. It's 2 a.m. A burglar kicks down your door, you protect your family, and a few months later, the intruder's family sues you for excessive force. It sounds impossible, but it's happened many times. Under this new ruling, those nightmare scenarios may finally end. The court established that if you use a firearm in lawful self-defense, you are immune from civil lawsuits filed by the attacker or their family. The burden now falls entirely on anyone who tries to sue you. They must first prove that your actions were criminal before any civil case can even begin. That one ruling could mean the difference between protecting your home and losing it afterward in legal fees. But what happens when your rights are violated by the very people sworn to protect them? The court had an answer for that too. Number 3, real accountability for law enforcement. For decades, police officers who illegally confiscated firearms or violated Second Amendment rights faced almost no consequences. A legal doctrine called qualified immunity protected them from personal responsibility. Even if they broke the law, citizens couldn't touch them. That shield just shattered. Under the new standard, officers can no longer hide behind qualified immunity in cases involving clear violations of gun rights. If an officer takes your lawfully owned weapon without probable cause or seizes it unlawfully, they now face personal civil liability. In Virginia just last month, an officer confiscated a man's concealed carry handgun during a routine traffic stop, even though the man had a valid permit and properly disclosed it. That officer now owes over $300,000 in personal damages. For the first time in modern history, there is real accountability for violations of your Second Amendment rights. But the ruling didn't stop there. It also took aim at the government's favorite backdoor method of disarming citizens, labeling every public area a gun-free zone. Number 4. Narrowing sensitive places. States like New York, New Jersey, and California figured out a clever way to skirt constitutional carry laws. They couldn't ban guns outright, so they declared nearly every public space a sensitive place, effectively banning firearms anywhere you might actually go. The November decision slammed that door shut. The court introduced a strict two-part test for what counts as a sensitive location. A courthouse with metal detectors and armed security qualifies. A school with on-site law enforcement qualifies. But a public park with nothing but a "no guns" sign? Not anymore. Private businesses can still ask you to leave if they catch you carrying, but they cannot have you arrested simply for being there. This ruling is forcing states to slash their lists of banned locations by as much as 80%. The map of where you can legally carry in America just got a whole lot bigger. But freedom delayed is still freedom denied. And for years, bureaucrats used delay as a weapon. Until now. Number 5. The 60-day permit rule. In many states, applying for a carry permit was like mailing a letter into a black hole. You'd send in the paperwork, and months, even years, would pass without a response. Some states sat on applications for 18 months or longer. It was a silent way to suppress gun ownership. The new ruling puts an end to that. Every state must now approve or deny a carry permit within 60 days of receiving an application. If the state fails to act within that window, the permit is automatically approved by default. No more excuses, no more endless waiting. If they don't respond, you're cleared. It's that simple. But there's one change even more practical. One that could determine whether your gun is useful when you need it most. Number 6. The ammunition storage mandates are gone. Several states had passed laws that sounded reasonable but were designed to cripple self-defense. Massachusetts required ammo to be stored separately from firearms. California required ammo to be kept in a different room. One county in Illinois even demanded they be stored on different floors of your house. In a real emergency, that meant your firearm was basically a paperweight. The November ruling wiped those laws off the books, stating that ammunition storage mandates preventing immediate access violate the Second Amendment. You now have the right to store your ammunition and firearms together in whatever way makes sense for your personal security needs. The government cannot dictate how you prepare to defend yourself inside your own home. But if storage laws were a quiet restriction, data tracking was a silent invasion. And that's where the next change hits hardest. Number 7. The end of state gun registries. For decades, politicians swore there was no national gun registry. Technically, they were right. But state-level databases told another story. California's dealer record of sale system contained information on every handgun purchase since 1996, more than 20 million records linking citizens to specific firearms. Hawaii required registration of every firearm in the state, including the make, model, serial number, and owner's details. The court called those systems what they are: illegal. Federal law has prohibited firearm registries since 1986, and this ruling enforces it. States maintaining such databases have 180 days to dismantle them and must send written confirmation to every affected gun owner once their data is destroyed. Failure to comply means contempt charges and daily fines until the systems are wiped. For millions of gun owners, this is the digital equivalent of taking the target off your back. But the fight against control doesn't stop at registries. It extends to the very businesses that keep firearms available. Number 8. Reforming federal firearms licensing. For years, the ATF weaponized federal firearms licenses, the FFLS, against dealers they didn't like. They would raid small shops, inspect every line of paperwork, and revoke licenses over the tiniest technical error. A wrong date, a missing check mark, even using blue ink instead of black. One Pennsylvania store lost its license because the owner accidentally wrote 2022 instead of 2023 on a form. That ends now. The new rule states that the ATF may only revoke a license for an actual criminal violation, not administrative mistakes. Agents must provide a written warning and give the license holder reasonable time to correct any errors. This change levels the playing field, protecting small businesses from being crushed by bureaucracy. The government can no longer use technicalities to destroy livelihoods, and that's a huge win. Because freedom doesn't matter if you can't cross a state line without breaking the law. Number 9. Expanded concealed carry reciprocity. For decades, the patchwork of state carry laws made travel a legal minefield. You could have a valid permit in Georgia, drive 20 miles into Florida, and suddenly become a criminal. That confusion just ended. The ruling establishes a national baseline. If you have a valid concealed carry permit from any state, at least 42 states must now honor it. Your Texas permit works in New Mexico. Your Arizona permit works in Florida. States cannot impose extra conditions on out-of-state carriers. If your permit is valid at home, it's valid across most of America. Officers in previously restrictive states are already being retrained to recognize this change. For the first time in decades, lawful gun owners can move freely without fear of crossing invisible borders. But when it comes to the most sacred place of all, your home, the court made sure that line is never crossed again. Number 10. Strengthened castle doctrine protections. In too many states, people who defended their homes faced two battles, one against the criminal and another against the prosecutor. Even in clear-cut self-defense cases, district attorneys would file charges to let the courts decide. That injustice just met its match. The new ruling shifts the burden of proof in home defense cases entirely onto the prosecution. If you use a firearm to defend yourself in your home or on your property, prosecutors must now prove beyond a reasonable doubt that your actions were not justified. No more homeowners spending months in jail for protecting their families. No more survivors becoming defendants. The law now presumes that your right to defend your home is absolute unless the state can prove otherwise. For countless Americans, that's not just a change in law. It's a restoration of common sense. These 10 rulings represent the most significant shift in American gun rights in generations. Together, they redefine what the Second Amendment means in practice. From how guns are stored and sold to how they're carried, used, and defended in court. But even with these victories, the battle isn't over. Anti-gun states are already drafting replacement bills, safety certifications, ammo tracking programs, even new forms of digital monitoring disguised as public safety measures. They're trying to rebuild what the courts just tore down. The next fight won't just be about guns. It will be about data, privacy, and the definition of freedom itself. So here's the question you have to ask yourself. Should any government have the power to demand permission for a right you were born with? Because if they can regulate one constitutional freedom, they can regulate them all. If you've made it this far, you're ahead of 90% of gun owners who still don't know these changes exist. Knowledge is power. And right now, it's your best defense. So take 1 second and like this video, drop a comment telling us which of these changes shocked you most, and subscribe to Firepower for continuing coverage as new rulings roll out. We'll break down every decision, every amendment, and every strategy states use to fight back, because you deserve the truth that the mainstream refuses to show. In this fight for freedom, information is ammunition. Stay sharp, stay free. And as always, this is Firepower signing off.